Objection.
And that the
Objection.
Okay, so this guy who's suing child support for $25 million. That was the end of this video. Was him showing a clip of, it looks like him objecting in court. This is the wrong way to object. And then, by the way, he's suing for Title 4D fraud and the administrative side. He doesn't tell you this up front. He's just as confusing as that guy Lionel. His username is child support is fraud, and he's running around talking a bunch of bullcrap about jurisdiction and all this stuff. If they don't serve you properly, then they'll just serve you again. But Lionel won because he wasn't the father of the child. This guy's saying some of the same type of stuff, and then all you guys believe that child support is going to go away. There's still child support in the laws, and you go to the family courts. He's only talking about division of child support or the administrative side or Title 4D, which is an easy win because it's already been won in Minnesota Supreme Court. I'll give him kudos. He's got some balls to do the stuff that he's doing and confront cops trying to intimidate him. So I'll give him kudos for that. He's just attacking the enemy with the wrong weapon and the wrong strategy and the wrong information. And a bunch of followers are making a bunch of weird, retarded comments. But let's talk about his objections here and how not to object. And then I'll also talk about other things he did wrong, like he paid child support without a child support order, and that's considered a gift, and he's trying to get that money back. He's not going to do that because anybody with half a brain knows you write child support in the memo of the check or child support in the transfer. We've seen all kinds of athletes talk about that's how they got out of it, or ones who didn't, they considered it as a gift. Anyway, he's in there saying objection, objection, and the judge is ignoring him. I think at one point she says, you'll be able to object later. You don't just go in and say objection. The judge is going to be annoyed with you if you're not an attorney. If you're an attorney, they'll say, oh, what's the basis of your objection? You have to state your basis of your objection hearsay, objection personal knowledge, objection lack of jurisdiction, objection res judicata, objection collateral estoppel, objection you're testifying, objection you're whatever. Anything in the evidence rules, any legal doctrine where you're not allowed to say that. What he's saying in the contents is that the judge is lying. You can't object to somebody lying. You have to prove that they're lying in an appeal, or you have to prove a witness is lying in cross-examination. This is where my gender's retarded. Somebody goes up and presents their case. You don't say, objection, they're lying. When it's your turn to talk, you get to prove they're lying. Objections are for stuff that's not allowed to be in court at all. You low vibration, low IQ, low level, only 3 brain cells firing retards. Folks just walking into court like I could just walk in and just say stuff because I heard Lionel from Child Support is Fraud say a couple things, so I'm just going to say a couple things. You need to sneak in and object. Now, a lot of times when you're pro se and you object to stuff, you say objection, and they'll say, what's your objection? They're talking about something that somebody else said. They'll say, shut up. You got to do it quick with one word. Objection hearsay. Objection personal knowledge. Objection collateral estoppel. Objection judicial estoppel. Objection lack of jurisdiction. Subject matter jurisdiction. Personal jurisdiction. Objection fundamental fairness doctrine right. Didn't get a chance to be heard. And they might say, what are you talking about? Now you get to jump in and talk. Here's the problem. Judges will say, you get your chance to talk. If something comes into the courtroom, and it's not allowed in the courtroom, and like you see in the movies, somebody will say, like a lawyer will say, weren't you there on the night of this and that? And they'll say objection, and they'll say withdrawn or sustained. The judge will say sustained, and they'll say withdrawn anyway, I'm withdrawing it. And they'll turn around and look at the jury like, yeah, I planted that seed in their head. Stuff that's not allowed in court is not allowed to be in court right now. The rules of evidence are a screen door. Now, most of you, if you listen to me and you go look at the rules of evidence, you will realize, oh, that's not allowed in court. And you will have half the brain God gave a monkey to use some common sense and say, well, if they start allowing hearsay, I better say objection hearsay and get it in quick and know what the hell I'm talking about. Some of you guys go, oh yeah, I heard objection when somebody says something that somebody else said and it's through the grapevine and blah, 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 blah. No, learn how to do this stuff the right way. Don't half-ass it and say, oh, I heard some rumor somewhere that hearsay is inadmissible. Read the rule and use some freaking common sense. That's not allowed in court right now. If the judge says, wait your turn, they're going to talk for 10 minutes and have oral argument, then you'll have oral argument. So they get to just violate the rules of evidence over and over and over again and allow the court to hear some hearsay, some personal knowledge violations, some expert testimony from a non-expert, and then be biased toward their side, and then I got to undo that? It should have never been in court in the first place. That's like if, let's say you're a batter in baseball, and the pitcher has Vaseline that he's slipping onto the ball, which makes it heavy on one side or makes interference with the air and makes it rotate and harder to hit. That pitcher has a device or item on them that's cheating. You can't tell the umpire, hey, look, he's got some Vaseline, and the umpire says, wait until the ball game is over with, then file an objection with the league. No, get it out right now. It's not allowed in there right now. You guys get this? It's right now it's not allowed. So you stand up to the judge and say, Your Honor, it's inadmissible right now. And then if you do some actual, even deeper research, violating the rules of evidence, the evidence rules are created for a fair hearing. If you don't have a fair hearing, you don't have due process. You don't have due process, the judgment is void. If you know all that, then you have a whole line of argument. But most of you are a bunch of lazy, half-assing bitches. And the reason why I'm saying this is to try and wake you up, because you'll go in and half-ass it and say, James, it didn't work. Because you didn't do all the stuff I'm talking about. Or sometimes in a video, I tell you a little hint of something, and you don't have the balls or the wherewithal or the diligence, and you're such a lazy bum, you'll just go off of my video and you'll walk in there and just, oh, some guy named James on the internet. I tell people where to find stuff to go research it yourself so you can be an expert on it. If there's somebody that says these herbs and these vitamins will help cleanse your system and help reverse type 2 diabetes or blood pressure, high blood pressure, or I don't know, psoriasis or something like that, and then you just go out and just take it, and you're supposed to take it in certain amounts at certain times, but you don't go and look at the times and the amounts, and you take a half-ass amount that doesn't work. You're like, oh, I tried it, it didn't work. Then you're stupid. Or supposedly there's a medicine that works or reverses something, and you don't take it according to the instructions, and you're like, that medicine didn't work. You heard about the medicine, but you got to apply it according to the instructions. If you heard about the rules of evidence, you don't just throw them out willy-nilly or just say, objection, you're lying. You have to prove somebody's lying, or you have to take the evidence and reconstruct that, or do a motion for reconsideration, or do an interlocutory appeal, go to a higher authority. Or if you're in front of a family law commissioner, you go to a judge on revision or mini appeal, or a magistrate to a judge, or whatever. But just like with medicine, you don't just randomly take a medicine and you need 3 pills 3 times a day with food, and you take 1 pill without food, and you're like, this doesn't work. You didn't follow all of the instructions, so you didn't do it right. And some of you guys, you half-ass something, you're like, well, I did that. No, you didn't. I had a video that says, talking about 2 different things, like going to court and doing or I talk about taking your kid and then going to ex parte to get an order that nobody could take the child out of state and get possession of the kid and stuff like that. This guy told me I did do that. I took my kid and I got in trouble, arrested. Later on, he won like 3 months later. But he lied. He didn't do what I said. And he's challenging what I said because, see, you guys will half-ass listen or half-ass not pay attention or half-ass something, and you say, well, I did that. And then you'll just lie, and then you'll be in delusion about what you actually did. You should listen. You should have the discipline, and you should love your kid enough to sit down and take the time to thoroughly investigate or read a matter, understand it, and learn it, or get a consult with me so you thoroughly learn something so you know how to do it. If I watch somebody do a transmission overhaul or a lube ball and filter, that doesn't mean I'm going to grasp everything, because something different or some part might be different in a different vehicle, and I might have to pull something out or move something around a different way. I need to understand the whole concept of how everything works. I can't just watch somebody do something and, oh, I got it down. You guys get this now? You can't just take a bit of information and half-ass it and think you're going to go to court and win. This guy went to court. He said, objection. He didn't say a precise objection with a precise basis and attack the judge for saying, oh, you can object later. That's not admissible right now. Now, it sounds like he had a totally misplaced objection. He thinks you can object to somebody lying. You got to prove somebody's lying when it's your case in chief or your oral argument or your time to present evidence. But a lot of you guys get this wrong. You don't know about this, and you have to thoroughly understand all aspects. If you don't thoroughly understand stuff, get a consult with me if you care about your kids enough to learn everything.